Hey friends, back, and we're doing a video segment on mediation. So in this video series, we've been talking about what mediation is, where it comes in the case. I like to think of it as like about halftime. It's usually after the parties have exchanged written questions back and forth to each other. But before I dive back into where we were, one thing I forgot to do in the last video series is give the rest of, where do you text Ashmore X2? Where do you send that? You don't just think it out into the Ethernet, right, into the interwebs. You text it to 47177. Text Ashmore X2 to 47177. It'll set up a chat dialogue with our team, and we're here to answer any questions. You can also email chat, C-H-A-T, just like it sounds, at ashmorelawfirm.com. Chat at ashmorelawfirm.com. Anyhow, back to mediations, right? It's usually about halftime. Parties know where the pieces are on the board. They've exchanged enough written discovery, written questions back and forth to each other, maybe interviewed some witnesses, maybe deposed, a formal deposition where they, were sworn in, testified in front of a court reporter type scenario, gave sworn testimony that's admissible in the court of law. At that point, mediation can be, not always is, but can be a very wise thing to do, because the parties then are in a position to analyze risk and maybe understand where they could compromise. And the thing about, back to what is the mediator? The mediator is in a civil dispute, probate, family, civil lawsuit between business owners, something like that. The court will almost always, almost without exception, order the parties to alternative dispute resolution of some kind with a mediator who's licensed 15, 20, 30, 40 years sometimes. And they know what the law applied to the facts gets you, right? So law plus facts equals this result. It's a prediction. It's not a guarantee. It's not, things happen at trial that are hard to predict, but they're just taking in all the information from both sides, making predictions about law plus facts equals what result, and the likelihood of where the judge may rule on some of those issues, right? On some of those questions that are presented. What about this and what about that? Well, the judge may do X, Y, and Z, or no, the judge may not do that. The judge more likely to do A, B, and C. It's their experience that you're relying on. It's one of the reasons why we always encourage clients to make that investment, right? Clients are always like, I don't want to pay a third lawyer. Why do I have to go to mediation? Because there's two big reasons, right? Because you must go to mediation if you ever want to see a trial, whether that be a trial with the judge or a trial with a jury. You must go to mediation, and almost universally. And no court, I've been in front of very few courts that have ever excused that. And even one time when the judge was thinking about excusing the clients from that requirement, the judge actually ordered us eventually to go, and guess what? It settled the case. And this was a very big dispute, one of the biggest disputes I've ever been, and the parties could not have been more distant, right, when the judge ordered the parties to mediation, but they found a way to compromise. I'll get into more of what that is in the next video segment. Thanks again for watching. Please like, subscribe, and share. If you have questions or comment, chat at ashmorelawfirm.com, chat at ashmorelawfirm.com, or hit us up by text, Ashmore X2 to 47177. We'll see you more in the studio next time on mediation. Thank you.